Litecoin Foundation, Blake Rizzo. Welcome.
Thanks, guys. Appreciate that. So I am the legal advisor to the Litecoin Foundation. I have had the pleasure of representing Litecoin since 2018. I currently represent a number of clients in the blockchain and crypto space. And I'm here today to kind of talk about, what's going on in the legal world. As you can see, I've got a bunch of alphabet soup on the title page there. And if you've been following along what's happening in the legal world, my guess is OMG or WTF have sort of resonated throughout the year. Vegas is a very special place to me because it was actually 4 years ago next week that I made the decision to leave a 21-year commercial litigation practice and dive headfirst into the crypto space. So it was actually after the Litecoin Summit and World CryptoCon. I was hanging out at Caesar's Palace here at an after party, and I was just overcome with a ton of emotion, and all of a sudden it was like I had this epiphany that I just had to stop everything I was doing and dive headfirst into the crypto space. And it's just been an amazing journey since then. Unfortunately, I was working at a firm that didn't understand crypto, and every time I tried to do something, they kept pushing back and said, that's all a bunch of crap, it's a scam, you're gonna get us sued, you can't do that. And so I made that decision, and I'm proud to say that it is the absolute best time that I've had practicing law in 26 years. So thank you to clients that I currently have, some of which are here today, like the Get Hedge folks who I really enjoy working with. Get to work with my good friend Matty Greenspan, who, if you don't subscribe to his newsletter at Quantum Economics, you definitely should. But before I get into sort of what's going on, typical legal disclaimer crap, I'm not your lawyer, I'm some of your lawyer, but none of this is legal advice. It's just my opinion on kind of where things are, so take it for what it's worth. So before we talk about 2022, I want to kind of go back to where we came from. So when I gave this speech in 2019, we had Mr. Clayton was the chairman at the time, and Commissioner Peirce was also there, and it seemed like the two of them were just kind of butting heads on everything. Clayton took the hard stance that all ICOs were securities, that we were going to apply the Howey test, and Commissioner Peirce kept pushing back, saying, wait a minute, guys, you're stifling innovation. We need better regulation. We can't do this with an 80-year-old Howey test. You're really disrupting the U.S. representation by dragging your heels. And so it was nice to see, Commissioner Peirce step up. She got dubbed Crypto Mom. And so, back then we were hopeful that regulation was coming. But we all know that regulation is a very slow process. So we were kind of left in this position. It's like, okay, SEC, what's going on, right? This is just the next iteration of money. We started with barter, gold, cash, credit. Now we're into the digital world. It's like, come on, let's go. Help us out here instead of trying to stifle innovation. So it was a very frustrating time from a legal perspective. Then things kind of leveled off and they weren't so bad. And Commissioner Clayton was on his way out. And so there was some sentiment that, okay, great, maybe this next commissioner that comes in, he'll be better. We'll be able to get more innovation, get someone that actually understands us and listens to us. And I was talking to Mr. Greenspan earlier this morning, and he had a good point. And he's like, look, it really doesn't matter who's in charge at the SEC. They all have an agenda because of the way the SEC operates. And it really doesn't matter. And so while some of us were hoping for something better, we got Mr. Gensler, who basically said, oh, you think Clayton was bad? Hold my beer and watch this. And since then, it's just been a whirlwind of everything's a security and I'm in charge. And so we've gone from what we thought was a bad SEC with Clayton to, I'll say, even worse with Gensler, because he just simply wants to control the entire world of crypto. So you'll see here are the cyber enforcement actions since 2017. There hasn't been a huge uptick in the amount of actions under Gensler, but that's all about to change because in May of 2022, he doubled the size of the enforcement unit, and they are going after basically everything crypto. So I would certainly expect to see a rise in the number of enforcement actions. And, you know, the number is not that important because, look, if people violate the law, they're doing illegal things, okay, fine, sue them. But you have to look at what the SEC is doing. Look behind the scenes, right? Everyone knows we've got this ongoing case with Ripple. And, you know, quite frankly, the SEC is getting their ass handed to them, right? I mean, they went after the big guy, or Clayton did. Gensler inherited it. But, you know, it's not easy. And so it seems like the current SEC has decided, well, we don't want to fight people that have the means to hire big gun lawyers that can make things tough for us. So let's take these little actions here and there where we can kind of try to backdoor a ruling that all these tokens are securities. And, you know, he's basically sort of taken the position these days that not only is everything in the space of security, but, you know, he's using these crazy arguments like, oh, you can hire a lawyer? Well, you must be a security. You have a foundation? Clearly a security. Wait, you didn't fully develop your platform where no other changes needed to be made while you're raising money? You're a security. And I mean, they've completely bastardized the Howey test to where if we applied the reasoning today, back then, it would mean oranges were securities and grocers could be in violation of securities laws. So there is a, you know, these litigation tactics and the way things are being handled. There is a well-known specific legal term that we use in these instances, and I think this picture here kind of represents that term. And for those of you who don't know, that's chicken shit. My daughter, by the way, who's watching, hey baby, excuse the curse words. I wanted to share this with you this morning. She texted me and asked me what I was doing, and she said, I told her I was looking at my slides, and she says, that's great. Make sure that you don't look at the screen the whole time and you don't have any grammar mistakes and that you say what the pictures mean. So, sweetheart, that's for you. I'm saying what the pictures mean. So please don't take any points off my grade for curse words. So anyway, you know, coming to 2022, we have seen a ton of legal action. There was 1 week in June where lawyers' heads were spinning because of all the stuff that was coming along. So in January of 2022, the SEC introduced this proposal about security exchanges, alternative trading systems, and basically, as written, it would have destroyed DeFi. And it was a very technical 600-plus page document, and the SEC gave 30 days for public comment. Of course, you know, Commissioner Peirce pushed back, saying, look, this proposal is going to stifle innovation, blockchain, DeFi. We have to give this more thought. You can't just bull rush these provisions through. So fortunately, the SEC relented and I think opened comments till something like June. And then in March, we had the executive order from President Biden that came out. It was finally like, okay, White House, thanks. You know, we've been waiting for this for 10 years, so, you know, thanks for finally coming to the table. And, you know, you looked at the executive order, and unfortunately, it was mostly centered around a central bank digital currency, which, you know, I don't particularly care about. I don't want the government to know what I'm doing with my crypto and finances. But, you know, he also told all the alphabet soup agencies that, you know, hey, you guys need to get together. We need to come up with a plan. We need to understand the risks. of what's going on and, kind of come up with a good, comprehensive game plan. It's like, okay, that's a good idea. But then I started thinking about it, and I don't know, how many of you remember Leroy Jenkins? If you don't know who Leroy Jenkins is, look it up. It's good for a laugh. But basically, it was a bunch of guys playing World of Warcraft, and the leader, kind of like Biden in this instance, was setting out this meticulous plan as to how they were going to defeat the enemy. And well, Leroy, he was just kind of not real happy, so he decided to take matters into his own hand, and in my mind, that's kind of like Gensler. And old Leroy, right in the middle of this conversation, just runs right into enemy territory, and he's like, Leroy Jenkins! And all hell breaks loose, and all the guys are standing around like, what's going on? And they all run in, and everybody just gets completely destroyed. They lose, and after the fact, everybody's like, what the hell? And so in my mind, even though the analogy doesn't perfectly work because Leroy ends up getting killed, in my mind, it's like the SEC is sort of Leroy Jenkins, right? They want control, and you guys can do whatever the hell you want. We're not going to wait around. Everything's a security, and I'm going to prove that. So that's kind of what we're left with. And then in June, there were a number of actions. We had the Responsible Financial Innovation Act, which was a great bipartisan bill that was very favorably received. Like any bill, it had issues, but it was great to see parties coming together that had obviously thought about this. And then in that 1 week I mentioned in June, we had, New York comes in, started issuing regulations for US-backed stablecoins. Coin Center filed suit against the Treasury Department because they didn't like the fact that transactions over $10,000 in crypto were going to have to be reported. There came a report that SEC lawyers were quitting at an unusual pace like never before seen. And some of the lawyers were even saying that they were not only didn't like Gensler's management style, but they felt like they were being forced down a path of litigation with no end in sight. They didn't see an end or the possibility of winning. Ripple, maybe? I don't know. But they just had a big problem with the way he was doing things. So we've had people, like very senior people quit, and a number of staff quit the SEC. And then also, Grayscale's been fighting the battle to get their Bitcoin ETF. So they've hired some big guns as their lawyers. And then one of kind of, this cool little thing that happened, which allows, kind of lawyers to nerd out on, is an NFT was used for the first time to serve legal process. So that was kind of cool. They basically dropped an NFT in a wallet, and the court ordered that if that person opened that wallet, then they were deemed to have been served. And it worked, and so that was kind of fun. So then in July, and this deserves its own slide, Magistrate Judge Annette Byrne issued her opinion with regard to the production of documents in the Ripple case. And the SEC is fighting tooth and nail to keep these documents from being public. And basically what Ripple wants are the drafts of the Hinman speech and emails when he basically had considered that Ethereum got a free pass. It was not a security. And so this is kind of odd for a judge to actually call out a governmental entity like, she did, but she said, basically this is hypocrisy here. She says, they're trying to get these emails, and she's basically saying that SEC is adopting its litigation practice to further its goal, which in my mind is basically to destroy crypto, and not out of faithful allegiance to the law, because they've changed their mind over and over and over trying to keep these documents from being produced. Now, fortunately, we learned this week that after 18 months and 6 court orders, the SEC has finally produced those documents. Of course, they're confidential, so we're not able to see them, but lawyer reactions who have indicate that it's going to be very interesting when some of that stuff comes to light. So I'm excited to see what happens there. Then in July comes the SEC versus Wahi case. And this is one of those chicken shit litigation tactics where the SEC, instead of suing Coinbase, decides to sue one of its former employees for insider trading. And I get that. Look, if you commit insider trading, that's wrong. Okay, SEC, sue them. But what they've done in the complaint, in addition to that, is basically listed 9 tokens, some of which are clear utility tokens or DAO governance tokens, claiming that they are securities. So they're clearly trying to get a ruling that these tokens are securities against individuals that don't have the means to fight back. And the commissioner found from the CFTC, in a bit of an unusual stance, called out Gensler and said, you know, this is clearly regulation by enforcement, and you can't be doing that. So that brings in August. I'm sure a lot of you saw what happened with OFAC and Tornado Cash. You know, OFAC has now listed a smart contract on the designated persons list who we're not supposed to do business with. You know, that's pretty big constitutional free speech violation there. And fortunately, we have a lot of people that are fighting back on that. But then the CFTC, almost as if they wanted to tell Gensler, oh, you think you're bad, watch this, they filed suit in the Oki DAO case. And again, if you do something wrong, sure, you should be sued. In this case, you had a couple of individuals that had a margin trading platform. They allowed US users to use it. They didn't register with CFTC, so they were in violation of the law. So what the CFTC did was they sued the 2 individuals, but then they had to go a step further, and after they settled with the individuals, and they sued the DAO. And basically, they are claiming that every single person in the DAO is personally liable for the violations. Now, lawyers back in 2017, when the first DAO report came out, thought that would be, you know, an argument that would be made. But some people look at this as more egregious than anything the SEC's done, because they're basically saying, just because I hold a governance token, I'm now personally liable for something that 2 individuals did. And they also basically served the DAO by dropping the complaint in a social media channel. And fortunately, we've had the Lex Punk Army and others fight back, and the judge has granted them has allowed them to file amicus briefs and fight that issue. So now we come to October, and what happens in October? Gary Gensler's got the win he wants. He got Kim Kardashian. Woo! I mean, don't you feel better knowing that Kim Kardashian's not going to harm you? I mean, really. So, you know, in what was an unprecedented move, not only did he announce the settlement, but he immediately went on CNBC to talk about it. And there's some of the staffers who were like, oh my God, this is such great publicity. You know, we can't buy this. We get Gensler with a picture of Kim Kardashian. Oh, this is awesome. And then you've got others who are like, wait a minute, this clearly violates protocol. There's no reason for us to do anything like this. It's clear that, you know, we think Gensler here has other political motives, and, you know, he's just doing this for the publicity. And then the other 2 things that happened this week was Sam from FTX. I'm sure you all know him. He came out with his sort of guidelines or proposals for how we need to treat the industry. Wasn't very well received because it seems to be certainly geared more towards protecting him, FTX, and centralized exchanges. And if you're into a little bit of drama, there are allegations that Sam and his lawyers actually stole work that BitBoy and his team was doing in the bill they're about to propose. So you want to kind of look at that. And I already mentioned that the Hinman documents were ordered to be produced this year. So, you know, at the end of the day, unfortunately, we were back at this place in 2018, and we're kind of still here today. It's like, okay, what does this mean? What are we supposed to do? And it's unfortunate, but lawyers are in a hard place right now, and some lawyers are actually being called out on this It seems like some of the big firms, and this is not a blanket statement, but big firms are very risk adverse. And they have to be very careful with what they do, so maybe they can't give the best advice. And Marco Santori from Kraken actually said this in a tweet last week. He's the chief legal officer at Kraken, and they've hired 56 lawyers. The exchange, they have their own freaking law firm at Kraken because he was not getting the help that he needed from big firms in the US. And he is a big firm lawyer. He's a former big firm lawyer. So, unfortunately, if you want to get involved in the space, you definitely need to talk to a lawyer. You need to figure out what it is you can and cannot do. Some people say, oh, well, I'm just going to go outside the US. But, the protections that you get from that are not as vast as people might think, because you still have to be very concerned with how you deal with the US. And so, I would advise definitely talk to a lawyer. Try to figure out what you can and cannot do. And hopefully the lawyer that you work with, can be creative and innovative, understands the space, and we can move forward. And, if you don't want to do that, you'd rather just kind of do it on your own. I don't know how many of you are familiar with this man here, but Mr. Roger Skear, S-K-E-A-R. I suggest you look him up on TikTok if you're not sure who he is. And he will be happy to tell you what you need to do based on how much you want to find out. So that is the end of my presentation. I thank you for your time. Appreciate you coming.